Welcome once again to the PLF Supreme Court Show. I'm joined by my colleague, Senior Attorney Oliver Dunford in our Separation of Powers group, and the newly minted Director of Constitutional Scholarship. Is that right? And stuff, Anastasia Bowden, who are joining us for the last day of the Supreme Court session, where we got 3 more opinions. We had 4 yesterday, so a total of 7 to talk to you about today. We're going to start with the 2 removal cases. Then we'll move on to the 2 big cases that are dominating the news right now on transgender athletes in sports and birthright citizenship. And then we also have a 4th Amendment case and a couple of First Amendment election law cases to talk about. A lot going on. Oliver, let's start with you. The big removal cases that I know I think you wrote about. You were part of an amicus brief in this case, and certainly issues that PLF has litigated and we were closely following. What was this case about? Pick one of them, and what did the court hold?
Yeah, 2 cases, one Trump v. Slaughter, the other Trump v. Cook. The question in each is whether the president properly removed officers in Slaughter. Rebecca Slaughter was a commissioner on the Federal Trade Commission, and in Trump v. Cook, Lisa Cook was and is a member of the Federal Reserve Board of Governors. So let's talk about Slaughter first. The question there is whether the president can remove a commissioner for no reason or any reason. The statute that covers the FTC says that the president may remove commissioners for cause, and the president fired her without cause, said she no longer followed the administration's priorities, and said that she was fired. She sued, and the question simply was whether the Constitution allows Congress to restrict removal in this way. And the court ultimately held that the Constitution precluded those restrictions, held that the 1926 case in Myers, in which President Wilson actually removed somebody from office. And then the big news, though, is that the case overturned Humphrey's executor. And in that case, President Roosevelt tried to fire Mr. Humphreys, and the court there said that the removal restriction applied. President Roosevelt did not have cause to remove Mr. Humphreys, or said that the president did so illegally. But in that case, the 1935 case, the court said that Mr. Humphrey's duties and the FTC in general back then exercised only quasi-judicial and quasi-legislative power, and did not exercise any executive power. And in the last 20 years or so, the U.S. Supreme Court has relied on that to say that the president still has full power to remove executive officers, at least the heads of agencies. The court did not get into whether inferior officers or civil service members could be removed, but the court did say that the president must have the power to remove the heads of agencies, at least when those agencies exercise solely executive power, as the FTC does here. So it was the court didn't break any new ground, at least not any new ground from its more recent decisions in Free Enterprise Fund and SELA law. Justice Gorsuch concurred, and his concurrence was interesting. He says, where do we go from here? Because the whole purpose of independent agencies like the FTC is that Congress gave the heads of these agencies some independence from the president's removal. And the conceit there is that these agencies are expert agencies and are less involved in politics. But Gorsuch says now that the removal restrictions have been removed, I guess, that now the president has all these powers, because these independent agencies exercise not just executive power, they also exercise judicial and legislative power, which means now the president exercises all these powers. And he said Congress can, of course, fix this by reining in these administrative agencies, or the court can. And he said maybe we should. We let Congress create all these agencies and let them run free for a while. Maybe it's our job.
I don't know if it was Anastasia or you, but I saw someone sort of internally here said, make Article 1 great again, right?
Exactly. There's no question. But to the and this gets to Justice Sotomayor's dissent, and she dissented along with Justices Kagan and KBJ. And she said that Congress has been doing this since at least 1935, since the Humphreys executor decision. And she says now we're pulling the rug out from under them. And she said something like the court has now reshaped government. To which I say Congress reshaped the government in the early 20th century and throughout the rest of the 20th century. And this is just
or the court helped reshape the government
and the court
in the
helped,
30s.
exactly,
Right?
gave them the imprimatur to do so. So this is just going back, I think, to the Constitution. It seems like a obviously correct decision that the president can't have executive agencies doing things that are outside of his control.
So Anastasia, is this overturning of Humphrey's executor, is this the sea change that some are making it out to be?
No, I think it's quite obvious that the court's been paring it back for some time now. It was almost a foregone conclusion. And in the majority opinion, they say, like, whatever's left of Humphreys, we now overturn. I did want to turn to something Oliver said about that Gorsuch concurrence. I found it really interesting for two reasons. One, he talks about how Congress can claw back its power, but now it's going to need to get a supermajority vote to overcome a presidential veto, because presumably presidents don't want to give up that power. And this is something he had, I can't remember what case it was. Was it like the student loan? He's been talking about that for a while now, and now it's come to fruition. He's like, how can Congress ever get it back? But secondly, for him to say, hey, there's actually some judicial doctrines at our disposal that we can step in and reign in the administrative state too, with like major questions doctrine, non-delegation, whatever. That's just surprising to me, because Gorsuch is so much of a minimalist in so many ways, and he's usually like saying that Lochner's bad and courts should get out of these decisions and whatever. And to see him for once actually say this is a judicial problem and the court can step in too, I thought that was surprising in a good way. But yeah, that's my thought.
Gorsuch also discussed a lot the progressive theories from Woodrow Wilson and others. And he should have cited to PLF's amicus brief, because we went through that a lot too. And the dissent, though, didn't mention it at all. And again, but the dissent talks about how we've had these kinds of agencies throughout our history, which is not true. And she just skips over the part and acts like, again, that this is the part of our history has always been these independent agencies. Woodrow Wilson and others were explicit that they didn't like the separation of powers, that they wanted to separate politics from administration. They wanted this fourth branch of government, these independent agencies. So it's just further proof that I think that this is the right decision. The dissent fails to grapple with any of that progressive history. And,
I think you have to have your head in the sand if you think that like Congress is functioning as it was intended, and that presidents and even congressmen themselves don't like fail to tackle the hard issues because once they get the levers they can pull with the agencies, that they just adopt whatever they want through agency whim. And the idea that some of these hot button topics ought to be debated openly in Congress seems to be how our structure of government was intended. And nothing in this opinion says that these laws can't be enacted or adopted or put on the throats of Americans, as much as I would hate it. But all it's saying is that agencies are responsible to the elected officials. It seems largely ho-hum to me. But on the other hand, I suppose that if you can get career bureaucrats in there who aren't responsive to the political branches, then they're just going to do whatever the hell they want. Come Congress be damned, President be damned, and that's even a scarier thought.
Yeah, we gave an example in our amicus brief of Trumka, former commissioner of the Consumer Product Safety Commission, who came out when Biden was president and said something like they were looking into banning gas stoves in people's homes. The chair at the time said, no, we're not actually doing that. And somebody asked the Biden administration, and he said, we have no comment. The CPSC is an independent agency. So there's a good example of the president, and Congress too, just here, you guys figure it out. We'll say we're doing something, but if something goes wrong, we can just blame the agencies.
So why then, Oliver, is the FEC not responsive to the president? Or the Federal Reserve?
Federal Reserve, yeah. And this is one thing that this is from the Slaughter opinion. Real quick, the court, and this was that both opinions, by the way, were written by Chief Justice Roberts. In the Slaughter opinion, Roberts said, "We are not addressing anything more than we have to in this case. We're not talking about judges. We're not talking about inferior officers, and we're also not talking about the Federal Reserve." And that part of the opinion was
or
not
the Boy
joined by
Scouts,
or the Boy Scouts, right? And that part
or
of the opinion
Georgetown.
was not joined by Justice Thomas, who dissented in the Federal Reserve case, and that is the Lisa Cook case, Trump versus Cook. And there, Trump said via Truth Social that Ms. Cook had maybe committed mortgage fraud and that she had to go. So like the commissioners of the FTC, the governors of the board, the Federal Reserve Board of Governors, may be removed by the president only for cause. So Trump, in this case, said he had cause, which was the alleged fraud, mortgage fraud by Ms. Cook. Again, he announced it and provided her notice through Truth Social. She sued, district court issued an injunction, and the district court, the appellate DC Circuit did not stay that decision. So it went to the Supreme Court. The Supreme Court put a stay on the district court's injunction requiring her to be put back in office, and then decided to grant cert before judgment. And so the court skipped ahead, really, and according to, I think it was Alito in his opinion, separate opinion, that the oral argument before the Supreme Court was only the second time that these issues had been debated in court at all. In any event, what the Supreme Court said is that the president had failed to provide proper process, which the court was careful to say didn't require a full-blown trial, could be on the papers, but had to have some kind of hearing. But Justice Thomas said in his dissent that the whole thing's unconstitutional. And so the Chief Justice, in the majority opinion, said, no, this is constitutional. These removal restrictions in the Federal Reserve Act are constitutional. And I'm not sure the court needed to go there. Justice Alito dissented with Gorsuch, and they said, we didn't need to do this. We think that the district court's reasons for granting the injunction were wrong. Justice Thomas, again, as I mentioned, dissented, said the whole thing's unconstitutional, and Justice Barrett, similar to Alito and Gorsuch, said that we didn't need to do this much.
So I guess I too found it surprising that Roberts, the minimalist that he is, decides to write that, no, this is constitutional when it doesn't seem necessary to the judgment. Why do you think he did that, Anastasia?
I mean, in my head, I'm like, are we getting based Justice Roberts? Like, he's just done. He's like, you're gonna make me say it. I'm just gonna say it. I don't know. It's true. It does seem contrary to his usual MO, but one feels like, we're just gonna wait for the whole thing to. It would have been a waste of judicial resources, I think, to let it come.
I think my theory is he couldn't get 5 votes unless he did. And unless he says that, it's going to be like a 4-4-1 fractured something, and that was sort of necessary to command the majority that got him to write. Anyway, pure speculation.
Maybe, but yeah. The one thing that I did find, although it wasn't mentioned anywhere, I don't think, although I didn't read all the dissents carefully, is that the progressive justices joined the majority opinion. This was Chief Justice Roberts, Kavanaugh, and Sotomayor, Kagan, and KBJ. And this was an interim docket case, a shadow docket case, and yet the progressives had no problem addressing the constitutional questions. Now, true, they had full merits briefing and oral argument, but it came to the court on a stay of a district court injunction without the benefit of even a circuit court opinion. So, again, it's just you see more of the shadow docket.
So what's the sort of takeaway of this? Is that the removal restrictions on the Federal Reserve are constitutional? Is she back on the Federal Reserve Board now?
Yeah, and Tom, that's one of the arguments that went back and forth. Is it proper to put her back in place while the merits are litigated? That's the other strange thing about this opinion. The merits technically have not been litigated yet. So I guess there still could be cause to remove her. But in the meantime, she's back at her job.
And maybe last question for Anastasia: Is it true that a post on Truth Social is not adequate notice for removal? Seems obvious.
Definitely. If it were my Twitter account, it would be adequate.
Yeah. Any further thoughts from either of you on these two important appointment clause cases?
Just that again, Justice Barrett noted in her dissent that if we were going to get to the constitutional question, it deserved more than a few paragraphs, which I think is definitely correct. It always seemed like the Federal Reserve was sui generis and that they were going to find some way around it, but it does seem like it was not given the attention it deserved in the opinion.
So why do you think it's sui generis?
Well, it does, because the money supply does seem like a non-executive function. On the other hand, as Thomas points out, the Fed does do a lot of executive functions. And so the Federal Reserve today is different from the Federal Reserve of 1913 when it was created. But the same argument applies to the FTC. The FTC was a lot less powerful than it is now. And all those independent agencies, they didn't have the power to impose sanctions or to at least fine sanctions should be imposed. And then, so a lot of things have changed, but I think that's probably the main one. And Justice Kavanaugh, in his concurring opinion on why we should address the merits now, or the constitutional question now, is because it otherwise would have wreaked havoc on the markets and the money supply and whatever else.
Ever the pragmatist.
Yes.
The two big cases in the news, Anastasia, which one should we tackle first? Let's tackle BPJ versus West Virginia, and what is it, Little v. Hecox, I believe is the other one. What were these cases about?
Okay, but I have to go back just really quickly, because one comment on those removal cases. I was a little disappointed that there wasn't more of a vindication of Justice Scalia and Morrison versus Olson. I feel like we're all kind of waiting for an opinion that really seized on his dissent, and we didn't get that. And especially because I think his dissent did such a good job of bringing out what's really at stake. Everybody sees these cases, now Trump has so much power over the administrative agencies, when in reality, the whole thing is that power is a zero-sum game. So who are you giving it to? The president, who we can, vote very directly out of office or not reelect, Congress, or unaccountable bureaucrats. And the whole point of housing it under the president is actually to empower us, the voters, the people. And I think Justice Scalia's opinion does such a good job of that, of flipping what people view as the equities, especially in this context right now. They're like, don't give Trump more power. And it's like, no, the reason we do that is to empower you, the voters. I felt sad that we didn't get that vindication, but okay.
For us Hojos who aren't as familiar with dissents, when was that case and what did it actually concern?
So Morrison versus Olson was Justice Scalia's first year on the bench. He was the solo dissent, which kind of, I think, set the tone for his willingness to be a strident voice on his own. But it had to do with removal restrictions on an independent counsel, and whether Congress could limit the president's ability to remove that independent counsel. And the court came up with this sort of balancing test to say, well, as long as it doesn't take away too much power. And Scalia has so many great turns of phrase in that opinion. The most famous one is, most times a wolf will come clad in sheep's clothing.
Right, okay,
this wolf comes as a wolf. But the turn of phrase that I really like, actually, when referring this balancing test, he says, referring to the way that the majority is characterizing restrictions on the president as being empowering to the president is sort of like referring to shackles as an effective means of locomotion. You're not allowed to shackle the president at all, and especially say that it's not too much of a shackle. Actually, he believed in the power of the president to the unitary executive theory. So it's a great opinion, and it was vindicated, but not really referred to. It wasn't altogether satisfying.
Okay, so
all right.
Trans girls and girl sports. Go.
Yes. So I believe it's 27 states now have passed laws that ban trans athletes from women's sports. West Virginia and Idaho. Idaho. West Virginia and Idaho were among the first, and 2 trans athletes sued, saying that these restrictions violate Title IX of the Civil Rights Act and the Equal Protection Clause. Today, in an opinion written by Justice Kavanaugh, joined by the Chief, Justice Thomas, Justice Alito, Gorsuch, and Barrett, they say that neither Title IX nor the Equal Protection Clause forbids states from enacting these bans. Now, that doesn't mean that states must ban trans athletes. They said that's a case for another day, but nothing in those 2 provisions disallows states from banning trans athletes, and so those bans will stand. I thought the opinion was really notable because Justice Kavanaugh famously was the coach of his daughter's basketball teams, very passionate about sports and his daughter's being in sports, and a big supporter of that. And you could really feel that throughout the opinion, just how much he cares about sports and about women's sports. But at the same time, very respectful to trans athletes, says, hey, I sympathize. I understand that they may want to compete and that they may not be able to compete in boys sports anymore because they've taken testosterone blockers or what have you. That means that they're no longer competitive in that sport. However, that's sports, right? Like, sports have to have a equal playing field. And so, my sympathy with them, but this is what the Constitution and civil rights laws allow. And then he also said, these athletes should not be ostracized. It's just that they can be, socially ostracized. They can just be banned from the sport. That's okay. That's constitutional. And then, of course, we got dissenting opinions, very passionate dissenting opinions from Justice Sotomayor, who was joined by Kagan and Jackson, and then a solo dissent by Justice Jackson. They actually concurred in the Title IX part of it. So all judges unanimously agreed that nothing in Title IX forbids the states from banning trans athletes in women's sports. But they said on the equal protection issue, there should have been more evidence, more hearings, that claim should have been allowed to proceed and shouldn't have been ruled on at this time. There should have been, you want to get into that?
Yeah, I remember when this case was argued, there was a lot of discussion and oral argument about the sort of whether you could have an as-applied equal protection challenge. Now, I haven't had a chance to go into this opinion in detail, but I know that was something that concerned you quite a bit. How does the opinion tackle that issue, or does it tackle that issue?
Yeah, it's something I actually have a little bit of sympathy for the 3 dissenters on this issue, because what the majority says is on its face, the ban does not violate equal protection, because it would be some athletes who, because they have undergone hormonal treatment, they don't enjoy the same advantage over women as other males. They said, well, but the law is closely tailored enough under intermediate scrutiny. And then they said there's also an as-applied challenge that these plaintiffs say, yeah, the law might be constitutional on its face, but it's not constitutional as applied to me. And they say that's what the majority says is that's kind of a backdoor into strict scrutiny. And it says it's also not judicially administratable. How are judges supposed to decide in every single case whether a person has sufficiently gotten rid of their competitive edge through the use of hormone blockers? And they said, like, basically because it's so difficult and because they viewed it as a backdoor into strict scrutiny, they just said, we don't think that's a claim. It's just, it's well enough tailored. And I think that's maybe erasing as-applied challenges a little bit. I think as-applied challenges require justices and judges to make difficult inquiries into whether a law is sufficiently tailored. And it doesn't raise the standard of scrutiny, it just changes the analysis. And that's sort of what the dissenters were saying. They were saying, you're getting rid of as-applied challenges here, and there should have been more hearings on whether the law is sufficiently tailored as applied to the plaintiffs.
So if that were true, would that mean that every individual trans athlete could bring similar claims, like one person in West Virginia may get to play in girls sports, whereas another person would not get to?
I mean, I don't know that would ever actually pass constitutional scrutiny, because there's evidence that, you never get rid of your biological advantage just because from in utero, embryos develop differently based on whether they are XX or XY. So I don't know that it would ever work. For me, it's just more of an analytical, I'm more interested in just like the legal framing of it, that I don't want to get rid of as applied challenges. But I don't necessarily think that it even means that any of those claims ever win. I just want the court to go through the motions.
Well, speaking of in utero differences, Justice Thomas had a short concurrence. What do you have to say?
Yeah, he wrote a very short concurrence, very to the point, pointed, that says effectively, in Justice Thomas's words, men are not women. And I'm not going to bow to any of these language games, which I think are, the beginning of tyranny, effectively. That, you start controlling language and you control how people think, and this is all a fiction.
Yeah, he went so far as to call transgender athletes suffering from a mental illness of gender dysphoria, or something to that extent, or at least he didn't say it outright. He certainly implied that it was a mental illness, and I don't believe anybody's telling his opinion.
And as a result, it could be rational basis. The scrutiny could be rational basis.
Yeah, that was his sort of legal point behind it, right? Is that this isn't entitled to heightened scrutiny. Well, let's move to the less controversial.
Well, hold on. Can I give one thing? Can I give a shout out to Spencer Davenport, who is one of our new SOP attorneys. He was with the Solicitor General's office in West Virginia and worked on that case.
Congratulations, Spencer.
Yeah.
Maybe there's at least one more thought to speculate into the future. There are current challenges going forward. Notably in California, we have a law that permits trans females to participate in girls' sports. Now, the court is clear today, I think Anastasia said, that this decision does not reach those laws, but there are challenges that allowing for biological males, trans females, to compete on female sports is discriminatory against biological females. And there are, I believe, both equal protection and Title IX challenges to those laws. Does this opinion, what are your thoughts on whether this opinion moves the needle on those decisions at all?
Yeah, one thing, if we could get any insight into how those cases might come out, there was a lot of talk about how under Title IX, there is an expectation that men and women will be treated differently in sports, and how that's built into Title IX and accommodated, by Title IX. And so even though they said we're not going to touch whether it's required, I don't know. It seemed, I don't know. We'll see.
Yeah, it seemed like Kavanaugh repeated over and over again the two reasons. One is for the safety of girls in contact sports, but elsewhere. And then secondly, to allow girls to participate. And so that second point would seem to suggest that, at least on the Title IX question, they might lean in favor of precluding biological.
Certainly insofar as sports have roster limits. Now, a lot of high school sports don't, and if you try out, at least growing up in Rhinelander, Wisconsin, that was the case. You just try out, you make the team. But that's not always the case, and now living in California, I know sports is highly competitive, and one person on the team means one fewer on the team. So yeah, I guess that question remains open, but those are some interesting insights into how the court might be thinking about these issues when they come, which I suppose they inevitably are. Do we know where those cases are in their litigation process?
I do not.
I just had one other thought.
Anastasia's using the royal we there.
All right, let's move on to birthright citizenship. What did the court
Birthright citizenship. Trump v. Barbara, Chief Justice Roberts wrote for a 5-4 majority, joined by Justices Sotomayor, Kagan, Barrett, and Jackson, where the court rejected Trump's executive order and held that children born in the United States, even if they're born to parents who are here unlawfully or temporarily, are still citizens at birth under the 14th Amendment and enjoy birthright citizenship. So preserved what has been the long-standing historical understanding of birthright citizenship, that it's extremely broad with very narrow limitations, for diplomats, children of diplomats, and children of enemy occupiers, effectively, are the only ones who have an exemption on that. Interesting, Justice Kavanaugh concurred in the judgment, but his reasoning was that Trump's executive order violated a federal law that was on the books. And he thinks that if it's rewritten, it might comply with that federal law, and the president could still narrow birthright citizenship as it's currently understood without running afoul of the Constitution. Kind of a unique Justice Kavanaugh concurrence there.
Was it 5-4 or 6-3?
Well, I don't know how to characterize it. It's
I guess
weird.
my question is, if Kavanaugh were to flip in a future case, would that?
Yeah, I don't think it matters.
That doesn't affect the constitutional holding.
It's 6-3 with his weird opinion. So even if you get rid of his weird opinion, then it becomes 5-4.
Yeah, seems like a pretty rock solid opinion.
Did the court have to address the constitutional issue? Could it have just ruled on whether Trump had the authority to do anything through executive order?
I mean, could have, didn't. I mean, that's what Kavanaugh says, effectively, like, we should have just taken this on statutory terms.
Okay.
Yeah. Now, what does the dissent say?
The Thomas, Gorsuch, and Alito dissent, very lengthy dissents, and they just disagree on the history. It's very comprehensive review of the history, and say, yeah, this was interesting. And Justice Jackson has a pretty long response about all of this, but I would say that the dissents take a very narrow look at the citizenship clause through the lens of what it was intended to remedy, that being Dred Scott, and the intention behind the 14th Amendment in offering citizenship to recently freed slaves and their progeny. And Justice Jackson, kind of takes Justice Thomas to task for that and says, you're the proponent of a colorblind constitution, that these words were written at the time of the 14th Amendment, but they apply to everyone, all generations in the future. And she thinks it's an overly crabbed view of the citizenship clause.
Mm-hmm. Interesting. Okay. Well, this also despite being both of these sort of highly charged cases came out exactly how we sort of expected them to come out. If anything, I'm surprised that there were 3 dissenters on the birthright citizenship case. I thought after oral argument that maybe 1, maybe 2, but the courts of appeals and the district courts were pretty uniform coming up on this issue. Last year, the court famously heard the CASA case that limited nationwide injunctions, and the dissenters in that CASA decision, the entire point of their dissent was, okay, maybe nationwide injunctions aren't a good remedy all the time, but with birthright citizenship, it's so obviously wrong that we should stop all this ridiculous litigation and end it. But and they were sort of lamenting that they didn't believe that the case would actually get to the Supreme Court, and lo and behold, the next year it does. The Supreme Court rules like I sort of think most of the legal academy thought they would. So despite these being high attention cases, I don't know that there's a whole lot there to digest. Certainly not really moving the constitutional needle much in either of these cases, as near as I can tell.
No, status quo, really it just keeps the status quo. One more interesting observation, I guess, was Alito wrote his own separate dissent to make the specific point that birthright citizenship is just the floor. So even though he believes that it's narrower than what the majority offers, he's saying, in my view, Congress can always broaden that. I thought that was just an interesting point that he wanted to write separately to make clear that was true.
So Congress passed a law that says, no matter where you're born, you're a U.S. citizen. We're citizens of the world.
No, he was saying, I think it only applies to people who are here lawfully and permanently, but Congress can broaden by saying anyone who's born here gets birthright citizenship.
So he would be open to sort of like what the majority got to, but only if done through an act of Congress and not through an interpretation of the Constitution.
Right.
We have 2 other cases that both involved the Republican National Committee in some aspect. The first is Watson versus Republican National Committee. Now, this was a Missouri law that permitted ballots to be counted if they were postmarked past Election Day. And at issue was federal Election Day statutes that talked about Election Day, and the question is, can states continue to count these ballots after Election Day if they were postmarked, if they were actually cast before Election Day? Is that consistent with the text of the statute? Or is Election Day, in other words, like an event that they have to be received on that day? The court, in a 5-4 opinion that frankly surprised me given how the oral argument went, ruled that postmarking on Election Day suffices to meet the statutory definitions, and therefore these ballots, these same-day ballots that are mailed in, especially here in California, almost all, I think 80 to 90% of elections are done by mail here in California. Those laws can stay on the books, and they don't. Election Day can mean essentially the day that you submit your ballot. This was a 5-4 opinion that sort of crossed political boundaries, as every 5-4 opinion does. The dissent would argue, I think as I mentioned, that Election Day, less so than a process, is more of an event, and when this event occurs is Election Day, and anything that happens after Election Day obviously isn't received by Election Day. I think one of the stronger points that the dissent has is that you don't really consider your ballot received until it's actually in the officials' hands that are going to do the counting. And if this is happening days after Election Day, then how can you say the ballot was received by Election Day? I think, on the other hand, the majority's view is also, I think they both try to take textual positions. It's Justice Barrett versus, I think, Justice Alito in dissent. And Justice Barrett's position is, look, you're trying to read more into Election Day than Congress wrote. We have a long history of sort of allowing permutations on what Election Day means. There is wiggle room here. If Congress wants to write it more strictly, it can go ahead and do it. But we're not going to read into this concept things that aren't necessarily obviously inherent in the concept. And so it's a 5-4 textualist decision. I think both sides have points. I don't really know where I lean insofar as the textual reading, but maybe my colleagues have different views.
One thing to note is that I think this is right, that everything had to be received within 5 days of the Election Day. So this is not like an open-ended, as long as you get it in, like, California elections, you can send them in 3 months later and they'll still probably be counted. I don't know if that affected Barrett's decision. If it had been more open-ended, maybe it would have been a problem, but 5 days, again, doesn't seem like a big deal, although if Election Day does mean Election Day, then maybe Alito's right, but it seems like either way, it's not a big deal, practically speaking, anyway.
Yeah. Anastasia?
No, I mean, I had the same feeling. I think that definitely played a part in the opinion. They say, bring us a different case if it goes on too long, but this is 5 days. It seems reasonable enough. Nothing explicitly prohibits that. And then if you're worried about the appearance of fraud, take it up with Congress. Doesn't it feel like that's the theme of almost all these decisions? Like, take it up with Congress. Take it up. I mean, if only we would, people, take it up with Congress.
Yeah, I mean, I think that retort would have had a lot more force 20, 30 years ago. And I don't know why we've become so polarized, but the idea that Congress can actually pass bipartisan legislation that would address these issues seems so far-fetched to me. Now, maybe that's just a product of the rampant administrative state that the court's pulling back on, and in 20 years we will return to a more normal stasis where Congress is doing its job. I don't know.
Well, this leads into the next case, but I read something about, well, Mark, you can discuss the next case first, but I have an interesting point on that, if I remember to bring it up.
So the next case is Republican Senatorial Committee versus the FEC. This case challenged the Federal Election Campaign Act limits on how much political parties can spend on their own candidates, as opposed to making independent expenditures. This case was the first sort of issue in this case that was pretty prevalent during the oral argument, if you recall, is that there was a lot of concerns about standing. And as someone who has fought standing many times, I was interested to see how the court would address this. But they essentially say J.D. Vance has had a senatorial campaign when the lawsuit was filed. He still has some sort of election bank account, and that's good enough, which when the court sort of waves its hand and says good enough, I'm like, well, why don't they say that it's good enough in like 95% of the cases that I litigate? But it's sort of, standing is always made up. I can get on my hobby horse and say how ridiculous standing decisions are, but they are sort of results driven. If the court wants to reach it, it's going to find a way to say that they're standing, and that's true here as well. Even though you can make just the strong case, as the dissent does, that there isn't standing here. Okay, end of rant.
Same thing the trans athletes case, right? One of the athletes said, I'm not going to do sports anymore. Please dismiss the case. And the court was like, no, you're not. You're going to hear it. You do have standing against your will.
It's so fake and it's so made up, and the idea that like case or I don't know. It's a rant for another day. But anyway, the court reaches the merits in this case. Interesting here, it does expressly overrule a decision called Colorado 2. Colorado 2 did limit how political parties could spend directly on candidates. This case overrules that and says that there's a First Amendment right of the political parties to spend, and these campaign limits are unconstitutional. I think the big concern by the dissent here is that if you don't have these campaign limits on political parties, that donors are going to funnel their money through the political parties, who are in turn going to influence candidates. We're going to be losing Anastasia. So Anastasia, any last words before we lose you?
Listen to what Joshua says. He's always right.
What am I?
You hear that, Oliver?
Yeah, I was going to say, what the hell? That's why we're not inviting her back.
Yeah, so the big concern of the dissent is sort of the influence that money plays in elections, which is the same sort of refrain you heard in Citizens United, the same refrain you hear in a lot of these campaign finance reform cases. I frankly don't see a whole hell of a lot of difference between a donor paying money to XY fund versus the political party. If anything, I think paying to the political party would make it more difficult for them to influence candidates, because the political party is such a bigger apparatus. Now, I assume there are certainly going to be times when the political party is going to directly funnel certain candidates, but I don't know. I sort of throw my hands up in the air in a lot of these types of cases.
Yeah, well, here's the thing. I think and was Kagan, right, wrote the dissent?
Yeah.
Yeah, she makes this point that the problem here is the coordination. And so if there was a ban on directly quid pro quo, that was the big issue, whether or not this would allow more quid pro quos. So Elon Musk, for example, could donate money to the Republican Party, and then the party could say to some individual candidate, we're going to work with you. By the way, this money came from Musk, and you know what he wants. So, and I don't know how you get around it. But Kavanaugh, in the majority opinion, took all these things. So that's a serious point. And part of me is thinking, no, it isn't. But we have all of these ridiculous First Amendment cases on the books that we have to get around. And so I think Kavanaugh is trying to take these concerns seriously. Bribery is a concern, obviously, and also he's trying to be respectful of the jurisprudence. But at some point, this is just ridiculous that we have to keep making these fine distinctions about campaign finance. I mean, let people spend money. The disclosure laws are still in the books. How much worse can it get?
Yeah, I mean, the idea that we're going to somehow limit money in politics, I think, is asinine when you have
a $7 trillion budget.
Exactly. They're spending so much money that it would be foolish not to, I don't know if foolish, but of course people want their slice of the pie, and they're going to sidle up to the trough. If you want to limit how people spend on elections, make the federal government less powerful so it can't do this.
Yeah, the line is, if you want money out of politics, get politics out of money. It's now the interesting thing, that the point I was going to make before is that and oh, this is one of my pet peeves, by the way. Justice Kagan's dissent starts with something like, for over half a century, the federal statute has guarded against quid pro quo. The progressives pretend that time and valid precedent began at the exact same time that their preferred policies began. So for over 50 years, we've had this law in the books. What about the first 200 years of the country? Sotomayor says we've had Humphreys for almost a century now. Okay, what about the time before that? None of that counts. It's just ridiculous. But one thing that perhaps is that before these new campaign finance laws, we had a lot more of the back smoke-filled back rooms where the parties would make decisions on who ran. And you mentioned before all the ideological divisions and the parties getting more and more spread apart, although some of them, we have Bernie Moreno and Elizabeth Warren getting together, so I don't know how far apart they actually are, but the point is the parties again. But what you've seen recently in the last few years is you've seen some nuts on both sides of the aisle getting elected, and most recently, of course, Mayor Mamdani's socialist friends have won the primaries. And so you wonder if the parties did have more control and were able to coordinate more, if they would restrict the money to more mainstream candidates, and you wouldn't have these extremes getting so much power in the parties. Now, I don't know. That's a question, but I have seen studies that show that may have been the case in the past. I don't know.
Yeah. I mean, I think it's fair. I mean, again, whether situation A or situation B or situation C is going to lead to more money being spent on politics, I don't know. I don't think and I don't know.
And do we really have less corruption? I just don't understand how. And the other thing is, if we do, is it really because of advertising and organizations and all that stuff? The corruption is because there is $7+ trillion at stake in every budget.
Doctrinally, I think it's worth saying that this was also sort of foreshadowed by many of the recent First Amendment cases in the election space, a point made by the majority. Colorado 2 was on its last legs, and this is sort of, foregone conclusion, not unlike the removal cases that we were talking about before with Humphrey's executor. So I don't think, again, that there's a whole lot of movement here other than an opportunity for people to cry about how much money is being spent in politics.
Yeah, the interesting point on that, though, is that Kavanaugh, in discussing why things have changed, and what the challenger said is that, well, the jurisprudence has changed more recently, which is interesting. Like, just flat out said, our jurisprudence has changed. We have different concerns now, and looking at those concerns, we rule in favor of the challenger. So it's kind of a stare decisis now is definitely not the formulaic restriction that it used to be.
Right.
Which is good.
Yeah.
At least on constitutional questions.
So we had one final case that came out, was it today or yesterday, the geofence case, Fourth Amendment case. Oliver, what was this one about?
Well, somebody robbed a bank, and the police wanted to try to track him down. And so they went to Google. They got a warrant, first of all, and they went to Google, and they wanted location data based on cell phone usage. And the warrant, though, had 3 levels, and each step kind of narrowed down the potential targets. And until the end, the information was kept anonymous, at least from the police. District court, when it went to, they narrowed it down. They arrested a guy with based on that and some other information. And then the defendant moved to suppress the evidence. District court said that it was a search, but there was an exception. I forget what the exception was, and so it was okay. Fourth Circuit said it wasn't even a search because the defendant had no expectation of privacy in 2 hours worth of location data. Mm-hmm. And the Supreme Court said no, it is a search, but the warrant here was proper. The defendant did have a reasonable expectation of privacy in that data, even though it went to a third party, Google, and not search of his phone or his private information. But the warrant with those 3 steps was careful, and so the warrant was reasonable, and the search was valid, and therefore I think it goes back now to determine. Actually, maybe it goes back to determine something. I forget exactly what. So it's not over, but the court did say it was a search, and that he did because the defendant did have a reasonable expectation of privacy.
Yeah, I think the dissenters, I think you call them the law and order dissenters, say something to the effect of, you are voluntarily giving Google your location data. So if you are giving that away, which you can turn off, even if you want to keep your cell phone, you can turn off your location data. If you're giving that away, how can you have a reasonable expectation of privacy in it? And, I think there's some force in that, but I would say that, we live in a modern world. These are sort of like the things that are part and parcel of living in a modern society. And if the government wants to get a whole bunch of information about me, I'm okay with them having to take the largely pro forma steps of getting a warrant. I don't know.
Yeah, the other thing that I think the dissenters are agreed on on the First Amendment case, which says that entities have free speech rights, or technically that individuals may get together and in the corporate forum and exercise their individual free speech rights. But it's the same thing. Google has rights, at least formally. People, I guess, this is kind of Mitt Romney's point. Corporations are people, my friends. So people are allowed to get together and in the corporate forum and do things, and they're allowed to. So we can have a deal with Google. We're going to give you some information so we can use your services. That doesn't automatically make things public. It just makes no sense to me that anything that a lot of people use automatically becomes public and lacks privacy. You can have a whole lot of people doing things and still remains private.
Yeah, that's true. But like in the legal context, if I am advising my client and there's a third party there and they overhear our conversation, then it's no longer protected.
Well, but if you're there with a third party expert witness or your secretary, that is maintained. And so here there's a now maybe this should be spelled out more in the user agreements that Google and all these tech companies issue every 20 minutes.
You read those user agreements?
I was going to say they come out every 20 minutes. I've never read one of them. But they could say, but we're going to keep your, and I think actually, didn't it change? I think some of these companies have changed their policies in recent years because of all this stuff. But in any event, it's a matter of contract. Ultimately, I think that you could look at it that way. That you're not on a public street making these announcements. And there's
it's akin to is this a poor analogy to draw that if you are renting a room in an apartment owned by somebody else, you still have an expectation of privacy in the room you rent?
Hotels, same. I think so. I think, maybe there's some difference, but it just doesn't. The other problem, and this is Justice Gorsuch's concurrence, is that he wanted the court to go back to a full property rights-based rule, and the Supreme Court said no, but it said that there were 2 bases. So I guess it's better than it says that you have property and the reasonable expectation of privacy. But the property seems to be a stronger basis, at least to your point about whether if everyone's using Google and do you really think you have everything's going to be kept private? But if it's Google's property or your and Google's property, it makes it a lot harder to justify a warrantless search, I think, anyway.
Right. It's hard for me to fully conceptualize how that would look in other sort of Fourth Amendment constructs, but like in your sort of traditional cop pulls over the car and smells weed, can he search the car? How would the property rights base analyze that?
Well, isn't it that that's one of the exceptions because there's a reasonable, articulable suspicion of wrongdoing or something? Now, maybe there are some people who, and I may be one of them, that says you always need a warrant. That the reasonable.
Well, they certainly had a reasonable suspicion that Google had. Well, I guess.
Yeah, but they got a warrant.
Yeah.
Yeah. So in other words, reasonableness does not excuse the warrant requirement, but the Supreme Court doesn't always apply that.
Yeah, I guess all I'm saying is that I'm sort of intuitively supportive of the property rights based focus of the Fourth Amendment, although I want to understand a little bit deeper how it works
Yeah, right.
in
That's right.
practice.
Yeah,
So,
yeah. And to these new types of property and ways of storing property and all that kind of stuff.
yeah.
And
So,
using the airwaves. That's the other wrinkle, perhaps.
yeah, fair. So that wraps up our Supreme Court season 2025 term, October 2025 term. Any big picture thoughts on this term?
No, not really. I wish, again, court needs to take more cases and and perhaps let things percolate, as our buddy Wenfa likes to say, before they jump to conclusions like in the Fed case. But no, I wish they'd take more. Do you have any cert petitions coming up, by the way?
Yes, we filed a cert petition in our case against Montgomery County, Maryland, where we are challenging their racial admissions process, so that they sort of remade their admissions at their selective middle schools in a race-neutral manner that we allege is intended to have a racial effect. Under the Fourth Circuit precedent that we lost in Coalition for TJ, the court says that you need to have alleged or shown that it has a aggregate disparate impact on the population. We dispute that, and there's a pretty clear circuit split now. We won a case in the Second Circuit, Cacagney versus Adams, and there was a companion case in the Third Circuit, litigated under Philadelphia, changes that Philadelphia Public Schools made. So since Coalition for TJ, this issue has not gone away. There's a pretty clear circuit split. We're hoping the court will take this case to resolve it. I'm on that case, but it's being litigated by my colleague Christopher Kieser as counsel of record. I am counsel of record in the case challenging a California law that requires continuing medical education courses to include discussion of implicit bias. We challenge that as a violation of the First Amendment as compelled speech, and we lost in the Ninth Circuit on the grounds that it was government speech, and therefore they could demand our client say whatever they want her to say. So we're petitioning that is not government speech, it's private speech. That case is fully briefed. We had a lot of nice amicus briefs from our friends in the movement, as well as a number of states and industry groups. There was a 3-judge dissental from the NBank petition from Judges Bumate, Van Dyke, and Tung. So very hopeful that case gets granted. I know PLF has another case. The Wilkins case is back for a second time. This is a case that we won on a Quiet Title Act that is now back up on the merits. I think it was just a statute of limitations question the first time around, but now it's up on the merits. So PLF has a lot of interesting cases. How about you? Do you have any petitions?
I think I'm going to have one, but we're still vetting everything, and then we'll see. It depends on how I have some other issues, but it depends on how quickly courts act. You know, we have to hit deadlines, but courts have no deadlines. So,
right, of course not. Oh, did I lose you? No, there you go. I guess for our listeners, we'll be back at least one more time next week to sort of wrap up. There were some petitions granted this week that we didn't get a chance to talk about. I'm sure the court will take some sort of final actions to wrap up its term. Maybe something there to talk about. So with that, we'll let you go. Oliver, I do have one quick trivia question for you. And this, now, I can't verify the accuracy of this, but this is ChatGPT's answer to this question. Today is June 30th, last day of the term. What is the latest calendar date on which the U.S. Supreme Court has concluded its October term?
it was not too long ago. It was like July 5th.
Well, July 5th is the latest in the 20th century, but that was in 1937.
Oh.
You're not wrong though, and July 1st was the last opinion of the 2023 term.
Okay.
July 3rd was in 1995, but the longest ever, which I was frankly surprised when I asked this question. I would have guessed that in some of the early years of the court, there would, would have
All
been
over
like,
the place. Yeah.
yeah, all over the place. But the latest known conclusion of a term was July 9th, 1831.
Huh. Was Marshall still there?
I think Marshall made it till 37. Don't quote me on that. But that's what I think is true.
Wow.
So,
Well,
anywho, maybe he set the standard and they just sort of kept
Right.
going.
yeah, that's true. Interesting.
Well, thank you to all our listeners, over 100 of you now on Twitter at least, and more on YouTube. We will be back sometime next week with a final wrap up of this year's term, maybe some more, some bigger thoughts on the big cases that were decided, what's coming up in the next term. But until then, Oliver Dunford, Anastasia Bowden, who joined us, thank you, and we'll see you next time.